Yes.
Chief Commissioner, I call the following witnesses, and I'll just indicate where they are seated within the hearing room. Senior Sergeant Philip Clark is seated in the witness box.
Thank you.
Senior Sergeant Leanne Weston is seated in the front row to your right, Chief Commissioner, and Senior Sergeant Andrew Pocock is seated next to Senior Sergeant Weston.
Yes, Mr. Coffey.
Thank you, Chief Commissioner. Could I assist that none of the witnesses require an objection or declaration?
Yes, thank you. All right, now there's three of you. It's probably a little unusual for you, but it's an efficient way of taking evidence. So we'll just have each of you sworn, I think, or sworn or affirmed. One after the other, I think, rather than all at once.
Silence. Do you swear by Almighty God that the evidence you shall give the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat.
Silence. Do you swear by Almighty God that the evidence you shall give the truth, the whole truth, and nothing but the truth, so help you God? I do. Silence. Do you swear by Almighty God that the evidence you shall give the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. All right. Yes, Mr. Fernandez.
Senior Sergeant Pocock, could you please state your full name?
Andrew Pocock.
Senior Sergeant Weston, could you please state your full name?
Yes, Leanne Francis Weston.
Senior Sergeant Clark, could you please state your full name?
Philip Joseph Clark.
I'm going to introduce you in what might be considered logical order because Senior Sergeant Pocock, you are very much responsible for the training of police, is that correct?
Yes, that's correct.
Senior Sergeant Weston, you're involved with training of police both at the academy and on an ongoing basis, is that right?
Correct.
And Senior Sergeant Clark, you're involved with continuing training of police, including once they are operationally in the field. Is that correct?
That's correct.
Senior Sergeant Pocock, are you the coordinator of the associate degree in policing practice?
Yes, I am.
Just explain what that associate degree is about.
Okay. We have at the Academy New South Wales Police as a constable education program. Constable education program is responsible for taking someone from the community and taking them to the point of being confirmed constable of police. A lot of the content in the constable education program is things like typing and running fitness and our COPS system, and then there's the primary component is academic, which is their academic learning, and to do that that component of the CEP is we work in partnership with Charles Sturt University, and
You said CEP, what's that?
That's the Constable Education Program.
Yes.
Sorry, that's the overarching program.
I'll just get you to pause for one moment. Could I just check that everyone in the room can hear?
It is a bit faint, Chief Commissioner. I wonder whether...
Yes, now there's a microphone there.
Is that better?
That's certainly better. I mean, I can hear, but it's those behind you, I think, who are the...
Great, thank you.
Okay.
But having the microphone handy will assist for everyone in the room. That would be good. Thank you. If you'd like to carry on. Yes, Mr. Fernandez.
You just explained that the CEP is the Constable Education Program.
Correct, and as the primary component of the Constable Education Program is the Associate Degree in Policing Practice, the ADPP, in which the New South Wales Police partners with Charles Sturt University to deliver that. I'm the coordinator for that ADPP from the police perspective.
There's also someone from
Yes,
the university, is that as well? Is that
as a curriculum manager, called the curriculum manager, and I am his counterpart, I suppose. Colleague.
The academy is at Goulburn, is that correct?
Correct.
And is that where the learning in terms of the associate degree takes place in terms of in-person, face-to-face learning?
Yes.
How, what length of time do police officers in training spend in person at Goulburn?
16 weeks.
Is there also a component of training which is online?
Yes, there is. There's session 1, which is 16 weeks online. Yes.
After the completion of the associate degree, a person becomes a probationary constable for a period of a year, is that correct?
Not quite. What happens after session 1, which is the 16-week online, session 2, 16-week at the police academy, that's when they become attested as a probationary constable. They're on probation for a year. In that year, they do 3 further academic sessions of academic study. They also obviously do on-the-job learning for that year, and there's an operational portfolio which they have to complete as part of the academic side of it. So there's as well. Then if they complete all that, they're confirmed as a constable of police.
You described the associate degrees involving more mundane tasks like typing, but in terms of substantive content, what are police officers in training taught?
Okay. The ADPP is an integrated curriculum. There's 4 subjects that we teach: law, policy and procedures, investigations, and then ethics and communication. They're 3 subjects that I primarily deal with. There's a weapons subject, which my counterpart, Senior Sergeant Weston, would be able to speak to. Within those subjects, we teach, well, I'll tell you, I suppose, we start off with 6 core policing capability mini modules. Those core policing capability mini modules deal with issues that are core to policing, such as, so there's the introduction to policing, there's decision making and problem solving, communications, ethics, victims of crime customer service, and then the final, what I call CPCs, or what we call CPCs, core policing capabilities, is the introduction to law and investigations. After that, we have in session 1, I think it's 10 modules or topics. Then in session 2, we have a further 7, and then we have numerous in year 2, which is in that probation year. The topics start with communities at risk. We deliberately put communities at risk as the first topic we do, because we think it's an important way to start our training after students have learnt the core policing capability around ethics. So we start with that topic, and then we move on to crime-related topics or issue-related topics, such as young people. We've got a whole topic that deals with young people. We have topics on larceny, domestic violence, assaults, things like that. So,
Have you just described very much the theoretical training or
Yes.
the substance of
Yes.
substantial training, whereas Senior Sergeant Weston deals with more practical aspects?
Yes.
Is that correct?
Especially from the perspective of the weapons side of it. Yeah.
Senior Sergeant Pocock, when you described an integrated curriculum, what do you mean?
Okay, so people might understand that at a university you might be in a particular subject, and that subject might be law. So you might attend a law lecture followed by law tutorials. Then you might go to, a different subject lecture on, I don't know, any sort of, geology or something like that. Our curriculum's integrated in the sense that all subject content or any subject content may be taught in any particular lesson, rather than specific siloed lessons that deal with that particular issue.
How is the curriculum put together? Who makes decisions on topics and content?
Okay, there's numerous ways in which that occurs. My team environmentally scans, so we're constantly looking at the environment to see what issues are topical. We actually do have a master plan that's been signed off at DCOP level, which is a 2-year plan, which provides some sort of direction on where we're heading with the curriculum.
When you say DCOP level, that's Deputy Commissioner.
Sorry,
Place.
sorry.
That's all right.
Chief Commissioner.
As I've discovered, there are many
Sorry.
shorthand terms.
At Deputy Commissioner level, as was approved at that level for us to go down that path. We get regular requests from our commander, Assistant Commissioner level, Deputy Commissioner level, to look at what we teach in relation to particular areas and asking us to do sometimes a report up to that level as to provide information on what we teach. That will sometimes come back with a request for us to enhance certain content. Coroner's recommendations, LEC recommendations. So there's a committee that exists that any substantial change to our curriculum goes through a courses committee, I think it's called, which is a combination of Charles Sturt University hierarchy and New South Wales Police hierarchy. And when I say that, it would be at the principal of the academy level.
I think you explained the question.
Sorry.
No apologies necessary. One of the systemic issues that this investigation has dealt with is an issue that has been before the courts for many years, at least 15 years, and there are cases which are in evidence in this investigation dealing with potential exclusion of interviews given by children after they've been given legal advice, and a number of different varied situations relating to the giving of legal advice. Can you just explain how do the latest developments in the law and how courts talk about police powers, for example, how do they find their way into the curriculum?
We will have a look. So sometimes information will come down via our commander with advice that it should be put in. It should be looked at and put into our curriculum in a way that our students will understand. In other instances, we will hear of matters that have been, or findings or matters that have been finalised, and we will look at our content and ensure that our content accurately reflects. I think some time ago, you want an example maybe?
What you've just described is either you yourselves as putting together the curriculum or being advised by others about important components. I'll come back later to talk about some specific aspects. Senior Sergeant Weston, I'm now going to turn to you. Is your role the coordinator of education and operational skills?
Yes.
Are you based at the Academy at Goulburn?
Yes.
What is it that you do in that role?
I act as a conduit between our business managers of our 5 business units and the commander of the command. I'm also a senior operational safety instructor, so I do deliver operational safety training to both the students at the academy and ongoing training to our sworn officers.
What is operational safety?
Operational safety, that relates to our policing and maintaining your own safety dependent on the environment that you face.
Does that include such things as tactical options available to police in situations where they're dealing with members of the public?
Absolutely. The tactical options model does guide our interactions with the public.
part of what you train police in is use of force, is that correct?
Correct.
Including the different types of use of force, as well as different options, including manual use of force as well as use of weapons. Would that be correct?
Yes, that is correct. When you say manual use of force, that is referred to as weaponless control, and that does form a part of the tactical options model.
In addition to teaching students in the associate degree, are you also responsible for ongoing training of police once they've been commissioned?
Yes.
Is there a mandatory training program required of all police?
Yes.
Is that in the form of continuing education?
Continuing education, you have your mandatory training directive for our operational police.
That means that police every year are required to do ongoing training and study, is that correct?
Correct. A training period, it's referred to.
Is there some practical training such as use of weapons, firing and what have you?
Yes.
Is there also a more theoretical component or substance?
Yes.
Are you responsible for both? Are you involved in both types of training?
In relation to operational safety, physical and technical, yes.
In terms of operational safety, let's say a police officer in general duties, how much training per year would a police officer get in operational safety?
2 days specifically.
Are there also opportunities for other training that police can seek during the course of
Yes.
their duties? I'm now going to turn to you then, Senior Sergeant Clark.
Just before you do that, just so I can understand this, with respect to the 2 days per year, do the police coming back for that continuing training all go to Goulburn for it, or is it done in regions?
We have, it's a region-based. So if you are at Goulburn, for example, you'll be trained by our Southern Region team. We have metro teams, so if you're stationed Sydney-wise, and that's across the state.
So if you're in the northern, southern, western metropolitan region, it's region-based.
Correct.
Yes, thank you.
Is the nature of your training that it's very much face-to-face, it's practical training, particularly in terms of use of weapons? Senior Sergeant Clark, are you the coordinator of learning development and delivery?
I'm the coordinator of the Field Development Unit, which sits within the that command, the Learning Development and Delivery Command.
What is it that you do? What are your responsibilities?
Within the Field Development Unit, our responsibilities include we create the mandatory learning components for each year as requested. We facilitate the delivery of those through. We have some. We provide information to the education and development officers. We provide the mandatory training through what's called the PEAT system, which is our online and other training system.
Can you just spell that? The what system?
PEAT, P-E-T-E, and it's a platform for delivery of training, which it includes a lot of online training and resources for face-to-face and blended training as well. We will facilitate the development of those mandatory training components. We have some involvement in the CDP, which is Constable Development Program, which is a program post-CEP where constables are looking towards promotion to senior constables, where we have mandatory training that they need to complete for that as well. Whereas we don't necessarily, we can't possibly deliver all this training ourselves. We have some oversight and a role in creating and facilitating the delivery of those programs and packages.
Are you also responsible for specialist courses such as the Detective Training Unit and courses for specialist officers?
The Learning Development and Design Command includes a number of sections. I've mentioned the field development unit that I'm part of. There's also a detectives training unit, which looks after the training of detectives and development of detectives. And there's the CPTU, the Crime Prevention Training Unit as well, which has a lot of specialist training units, including specialist youth officer training, domestic violence officer training. Yes, what else? You had Sergeant Edgell from the custody management training. There are a number of others as well that are all attached through the CPTU, which belong to the Learning, Development and Design Command.
Are you also responsible for putting together resources for police on topics such as police powers?
We will facilitate the creation and availability of resources for ongoing education, including I have some responsibility for the Police Powers portal, which is an intranet-based site with resources that relate to powers and use of force.
Does that mean the portal, does that mean that all police officers have access to that information if they go into the police intranet site?
Yes, that portal is available through the intranet site, and what it does is reference resources on the PEAT platform and in other locations as well as, as are relevant to each of those pieces needed.
It's because one of the matters that I'll be raising specifically is about police powers. Just to pick police powers, are there continuing courses available to police officers, for example, on issues such as police powers, use of arrest, and other related topics?
There are learning products available, so there's everything from what we call SMITs, or I think it stands for 6-minute intensive training pieces, which can be used in the station for whatever purpose. There's larger articles like law, what we call law on articles, which address things like arrest or search or many other issues. There's links to training packages in the PEAT system, which may include online packages, SCORM packages, or even materials that the EDO can deliver face-to-face or in a blended fashion as well. So there's multiple resources available to individual police officers and to education development officers and commands as needed.
Is it possible, do you have the technology to keep account of how often those resources are actually being accessed through these portals?
There is, for each of those resources, I think if a course is run, generally attendance is taken, and there may be a proficiency attached to the course where the person can, or the EDO can, or the lead educator for that course can sign that person off as having attended that course. Even for some of the smaller pieces like the SMITs that I mentioned, the 6-minute intensive training, they can indicate that they have completed that course, read that material and completed that course.
By way of background, Senior Sergeant Clark, you actually have a degree in law, is that correct?
That's correct.
And science, is that right?
That's correct.
Yes.
Your time in police, after working in general duties, did you work as a police prosecutor for a number of years?
I spent about 3 years in front of the court, and then I went to the training unit after that.
You were a trainer for about 6 years, is that right? Between 2012 and 2018?
Yes, I continued training. I took on a coordinator role or legal advocate role, but I kept training right through to 2022 with the training unit.
What did that coordinator or legal advocate role involve? How was that different to what a police prosecutor might normally do?
I didn't attend court that often, and my job was developing materials and delivering classes to training prosecutors.
In relation to that matter, can I ask you whether in that role, was there ever any communication with the training of police through the associate degree course to raise frequent legal issues that were arising? Was that something that you were involved in?
The frequent, we would, in training, as in from the training unit back to the academy is the issue.
For example, Senior Sergeant Pocock described how the curriculum is developed, both through looking himself, as well as getting feedback from coronial recommendations or others, commanders. Was there ever any component or aspect of your work, being a police prosecutor and then training police prosecutors, to say this is a recurring legal issue, police should be trained in that? Was that ever something that you did?
Recurring issues in court would be dealt with through the normal channels. There's a failed prosecution process, where if a prosecution doesn't succeed, there is a review process for those prosecutions. And if there are any patterns, there are people within the prosecutions command who do look for that information, and even within local areas, they will review the failed prosecutions within the command to see if there are recurrent problems.
When you say within a command, is that very much on a regional basis that you're describing?
That within a local area or a district.
One of the systemic issues that this investigation is looking at is about, after children give interviews, if there's a question about admissibility, about how those admissibility questions are determined by courts. And there are judgments of the Supreme Court, District Court and Children's Court that are in evidence before this investigation. Is there a way that those judgments, those determinations by the courts are provided to police prosecutors to say, this is the latest law, this is what you need to be aware of?
I can't speak for the prosecutors now.
In terms of your training, when you were a trainer?
In my role, it was for each of we would have a responsibility, or there would be areas that we would train on in specialist areas, and would each individually keep an eye on the relevant changes to the law, whether it be legislative or case-based or policy-driven changes. It was the responsibility of each of the trainers, but it was a reasonably collegiate environment in that we would work with each other, or we have multiple resources to identify changes in law, not least of which is the internal processes of the police, where they will issue from the Office of General Counsel or otherwise, they would often issue emails and notices of changes to the law as well. In addition, things like we'd have feeds of current awareness from Westlaw, from Lexis. I would regularly deliver to all prosecutors, not just the trainers, copies of the criminal law news and other products that would alert prosecutors and trainers to any developments in law.
Just lastly, on this line of questioning, you've just described how you as police prosecutors would receive that information, and
yes,
that legal information. What about sharing that information? Was there a process by which police in training could be provided with that information? So someone like Sergeant Pocock could be made aware of, this is a frequent issue, police need to be taught about that.
I don't think it was the mandate of the prosecutor training unit to necessarily inform. However, depending on the relationship with the trainer and the information needed, I didn't have a regular conduit with the academy that I recall. But yeah, we wouldn't withhold information.
It was about the sharing of information, not the withholding. It was about the sharing of
Sorry.
information. Was there any process for that to take place?
Again, if I am not aware of that process, although it's usually information, we were taking information that was available to all police, or disseminated through what we call nemesis messages, or I can't recall specifically
I think you've answered that.
providing information to the Golden Keepers.
I'm going to turn to the first topic that I'm going to raise with each of you, and firstly with you, Senior Sergeant Pocock, and that's about what training is provided both to officers in training and then afterwards about alternatives to arrest. Senior Sergeant Pocock, you referred in your evidence earlier to communication. What is taught as part of the associate degree to police officers in training about alternatives to arrest?
It's probably important to point out to start with that it's probably important to point out to start with that we would on a lot of these issues that are very important. What we will do is we will address the issue numerous times throughout the curriculum. So probably the easiest way is for me to it's addressed numerous times. I can give you examples if you like.
Could you summarise what's taught? What are police taught about when to arrest someone and what the alternatives are to arrest?
Okay, we're taught a lot. We teach a lot in relation to arrest. We teach what an arrest is. We teach when. Can I start? Do you want arrest or do you want alternatives to arrest?
Let's start with the alternatives.
Yeah, okay. So we start lesson 1. We start with Peel's principles very quickly. Yeah, Sir Robert Peel's 9 principles. This is in our first lesson. His first principle with law enforcement, the basic commission for which police exist, is to prevent crime and disorder as an alternative to the repression of crime and disorder by military force or severity of legal punishment. So right from lesson 1, we're starting to lay the foundations of what policing is, and it's not military force or legal punishment. And there's another legal principle in here which talks about in Peel's where police should use physical force to the extent necessary to us, and we start with Peel's principles. A couple of lessons later, we talk about police discretion, and in the police discretion lesson, we talk about an acronym STOPA, which is in our decision-making and problem-solving. STOPA is our decision-making and problem-solving.
Is that STOPA?
Yeah, R.
AR, yes.
Yep. So
does that stand for stop, think, observe, plan, act, review?
Yes, and it's in the plan. For example, this is the first one of the early lessons. The plan stage refers to what action police are going to take with this decision based on the least restrictive form of sanction. So we talk about the least restrictive form of sanction, such as no action, issuing a warning, move on direction, fixed penalty notice, field court attendance notice, future service court attendance notice, or arrest. So that's in probably, I'd say, that's the 7th lesson that these students learn. We provide, in that same lesson, we give a few examples. We talk about when section 99, 1A, we highlight the point that in section 99, 1A or section 99,
I'll come to that very shortly, because section 99 deals with the powers of police to arrest without a warrant, and I'll turn to that very directly. Are you saying that's part and parcel of consideration of alternatives to? Could you explain that?
Yes, because we say the use of the word may, as opposed to will or must or shall.
What I might do is put section 99 up on the screen.
If we could put that up on the screen, and
Yep.
if there's some way of reducing the static.
So we point out.
So we might just focus in on section 99,
Yeah.
subsection 1A and B.
Yeah, so particularly
Just in particular.
what our lesson highlights is a police officer may. So in this stage, when we're not actually dealing with arrests, we're dealing with discretion. but what we bring to their attention is the fact that they may, doesn't say you shall arrest, doesn't say you must arrest, doesn't say you will arrest, clearly denotes that you may arrest. And we highlight the fact that well, I'll just say what it says here, it's easier. The legislation allows for police to exercise their discretion on how to lawfully proceed. In future lessons, you'll learn what the alternatives to arrest are, notwithstanding that we've just highlighted them, and how they are applied using appropriate police discretion. Then in the same lesson, we go on to section 231, which again indicates that you may. The word may in section 231 implies that police do not have to use force in every arrest situation, while the term reasonably necessary allows for police to use their discretion to determine when the use of force is justified and the level of force that is needed. So whilst these issues are use of force related and arrest related, we don't silo things like that. They need to understand them in context, and so therefore alternatives to arrest the discussion with alternative to arrest interrelates really with our discussions on arrest and discontinue an arrest, because you may have arrested somebody and then situations may change, which leads to an alternative to the arrest situation of taking someone back to the police station, and then also even in 231.
Appreciate you described an integrated curriculum
Yes.
where topics aren't siloed.
That's right.
But nevertheless, there is some discussion among all of those different powers. So
Yeah.
in terms of the powers of arrest requires an understanding of the alternatives to
Yes.
arrest. Is
Yes,
that
that's
right?
right.
Is there any training on what can assist a police officer in his or her discretion on whether to arrest a person or to use an alternative to an arrest? How's that discretion guided?
Yes. If you give me a moment, it's a big beast. So our curriculum. So alternatives to arrest is in a subsequent lesson again. It's still in our core policing capability, part of the curriculum, and.
Perhaps I'll come back to that if I can ask you just to consider
Yep.
if there's any guidance on discretion, because in many police powers there is a discretion. Would that be correct to say?
Okay. So what we teach is that you should take the least restrictive form of sanction. We teach it numerous times throughout the curriculum that, and we start with Peel's principles to indicate that we're not above the law. We work, we work for the community. Through their whole learning, the emphasis is how can we do whatever business we need, policing business we need to do with the least impact on all people involved, to be honest.
Is there anything else you wish to say about training in the associate degree program about alternatives to arrest?
Not other than we cover it quite extensively, I would suggest.
Senior Sergeant Weston, is this issue of alternatives to arrest something that you have any involvement in terms of training or ongoing training?
Not specifically. We focus more on the physical aspect of an arrest or control methods.
Senior Sergeant Clark, in terms of this particular issue that I've just highlighted, alternatives to arrest, what materials are available on this topic? What training materials are available? What training is provided?
I can't off the top of my head think of any particular piece that relates only to alternatives of arrest, and it's something that'll be in the context of the arrest situation, in terms of how a matter is dealt with. In particular,
if it's, are there some resources available? Or is that
Nothing
something?
specifically comes to mind, but I haven't reviewed all the documents that have been provided with that particular idea in mind. I imagine, if you look to the specialist youth officers, it's not alternatives to arrest, but the way the way of dealing with the matter rather than charge, and whether you consider that as an alternative to arrest, or when a matter is discontinued, how the matter may, or an arrest is discontinued, how it might be dealt with subsequent to that, whether that's regarded as an alternative to arrest, or if you're just thinking pre-arrest considerations.
Pre-arrest considerations
Yes.
was what I was drawing your attention to. It may be that something that Sergeant
I'd
Pocock
have to-
really has.
I'd have to look at the documents with that in mind.
I'll turn then to the powers of arrest. I think section 99 is up on the screen.
Yeah.
And I'll return to you, Senior Sergeant Pocock. Section 99 of the Law Enforcement Powers and Responsibilities Act sets out the power of police officers to arrest without warrant. Those powers to arrest are based on two matters. Firstly, whether the police officer suspects on reasonable grounds that a person is committing or has committed an offence, and the police officer is satisfied that the arrest is reasonably necessary for a number of reasons which are set out in subsection 99, subsection 1B. I'm going to take you firstly to the reasonable grounds for suspecting that a person has committed or is committing an offence. What training, what guidance is provided to police officers about reasonable grounds and what that actually means?
We have quite a number of lessons which in part address this issue. I guess, bearing in mind that our students it's a 101 level, it's low level, they're only students. So we talk about realistically when they address a situation where there's a possibility that somebody may be arrested, they have to have, they must suspect on reasonable grounds, and we talk about suspicion. We talk about suspicion, we talk about the objective-subjective test. So you may believe, or you may have a suspicion that you think that the person may have committed an offence, but that it needs to be an objective, an objective test to that as well. Because the reason we teach that is reasonable grounds relates not only to arrest, it relates to searching, which is a big ticket item for us as well. So we try not to confuse them. We just, whenever we come to suspect on reasonable grounds, you've got to have a subjective test, an objective test, and then the information that you have is to be reasonable. So one of the things we use, if you like, is we talk about a glass cylinder, a glass cup, and every piece of information that goes into that glass cup is your grounds for reason, is grounds towards your suspicion. The more information that you have going into that glass cup would reach the top of that glass cup, and arguably the top of the glass cup is when you reach a reasonable suspicion.
What about
use techniques like that to try and encourage students to look at information and determine whether that information is going to lead you to a point of suspecting on reasonable grounds that someone's required for an arrest or you have reasonable grounds.
Is there any training about what needs to be considered to decide whether a person has committed an offence? Because offences can either be observed by people or police, or they might be not observed.
There's training that you because most or very often the offences that are committed are not witnessed by police. So police are required then to go and investigate a matter and take statements from witnesses, and there's a lot of training that we deliver in relation to how to gather that evidence. and then make an assessment on whether or not they're going to proceed, and then whether it's an arrest situation or not situation. So we teach a lot of our curriculum deals with offence categories. So we teach, for example, a whole topic on street offences, offensive conduct, offensive language, knife offences, things like that. And so we teach the crime, and then we teach, well, what are you going to do about that? If you see in this scenario, you see that crime committed, okay, is it an arrest situation? Or what are you going to do about that? What power are you going to use in the dealing with that situation?
I'm going to take you very shortly to subsection 1B about satisfaction that arrest is reasonably necessary.
Yeah.
Now, those terms, reasonable grounds and reasonably necessary, they're terms that are considered, they're legal terms, and they've been considered by courts. What training is given to police officers specifically about what that means? What level of satisfaction has to be held before a person is satisfied that arrest is necessary?
I would have to go through and have a look specifically. I can't right at this moment put my finger on where in our curriculum we would address the issue of reasonable. I would probably suggest, to be honest, that it would be addressed in the searching area more so.
I might come back to that after lunch to give you that opportunity. But could I ask you this question, Senior Sergeant Pocock? You said teaching at the academy and the associate degree program was a 101, so it was an introduction for police in training. After the academy, what other opportunities are there for police to be given training in these very matters, when arrest should be utilised and when it shouldn't?
Do you mean during their probationary year or?
Any time after their time?
Well, during their probationary year, they work with a senior officer, and that they do on-the-job learning. So there's that component of it, and then during that year and subsequent to that year, there's numerous PEAT courses which you can access at any time and go and have a look at that.
Is it contained in course materials as part of the associate degree program what these terms mean? Is there some discussion or teaching of what they mean within the course materials?
There is. I'd have to go and to find exactly, particularly around the word reasonable, as to what we teach specifically around that. So there is, but yeah, I'd have to find it.
Are there case studies used as part of the teaching?
Case studies and scenarios and some references to case law also.
Those case studies are used to assist or to discuss the different ways that police powers can be used, is that
Yes.
right?
Yeah.
Is there anything else involved in training in terms of, at the academy, as part of the associate degree course, in terms of powers of arrest? Anything that you haven't referred to already that's taught as part of powers of arrest to police in training?
Yes, we also talk about 99.3 as a particularly relevant component of your power to arrest.
Perhaps we can just bring that up. That section refers to taking a person as soon as reasonably practicable before an authorised officer.
The way we primarily teach that, I guess, to bring it down to basics, would be we don't arrest to interview people. You can't arrest somebody to interview someone. Your intention at the time of arrest is to put that person before the court. That's the way we deliver that information to. And if you don't have that intention, then you cannot arrest.
Do you deal specifically with arresting a person for the purpose of identifying them?
Yes, in the sense that some of our scenarios will have situations where an offence has been committed, and I think one of our scenarios is they walk up to the person is compliant in the sense of willing to talk to them, and they're investigating the matter, and they ask the person's name because their intention is to probably give them a SIN or a criminal infringement notice or field can, and the person says, yeah, my name's Donald Duck and I live on the moon. And so therefore, what we teach essentially is you want to use your communication skills to try and work with that person in order to avoid the arrest and taking them back, placing them in custody to issue a can. But realistically, if the situation is that that person is not going to provide their details, then you may need to arrest them under it. That would be a 99(1)(b) reason to arrest that person.
Senior Sergeant Clark, can I turn to you? Senior Sergeant Pocock has talked about the associate degree and what's taught there. In terms of your areas of responsibility, what materials or training is provided on an ongoing basis in terms of powers of arrest?
Just thinking, the material reference from the portal site includes a number of what we call law on articles, in particular an article from the Police Gazette regarding arrest. There's reference and a link to the material in the handbook on arrests. So there's a lot of information available. I don't think there's a specific course on arrest that we reference and that it's dealt with in other contexts. But yeah, there is a lot of other information available about arrests that is updated and available.
And does that also specifically include the power to arrest?
It's there is a lot of the power to arrest under Section 99 or otherwise. Those articles do address that, and the handbook and other pieces do address that.
Senior Sergeant Pocock, I'm going to return to you, and I'm going to ask you specifically, before I turn to Section 8 of the Children Criminal Proceedings Act, to what is taught as part of the associate degree in terms of children and the law and children relating to their contact with police. What are police officers doing the associate degree taught in terms of children and the law?
We have a complete topic devoted to interacting with young people, which is 9 lessons. Those lessons are 1 hour and 50 minutes each. And in those lessons we deal with, sorry, if you give me just 2 seconds. Those lessons are interaction with youth. So it's a introduction lesson which just sets the scene of the fact that police will interact with youth more because youth are on the street more and they hang around more. So that doesn't necessarily mean that young people are doing the wrong thing. It's just it's a social environment issue. So that we start with that. Then in the second lesson we have another lesson, risk factors for youth as victims and offenders. So we address the issues that young people face, which are going to increase the risk of them being involved interacting with police as either a victim or offender. Then we have a lesson on youth development. We talk particularly about brain development and the fact that in young people, the brain, particular elements of the brain develop later, and therefore they're not so adept at understanding risk and repercussions for actions and things like that. So as part of that, and in that lesson, we introduce court diversions, and we talk about the stand that the New South Wales, I suppose the whole legal community takes in regards to trying to divert young people out of the court system. A big part of, before I go on, a big part of that area of the curriculum is we do introduce the Young Offenders Act at this point, and a point we make is we don't treat children different or young people different because of the Young Offenders Act. The Young Offenders Act exists because children need to be treated differently. So that's a core fundamental concept that is part of the training. We then deal with the Young Offenders Act. We then give a whole lesson.
I'm sorry to stop you, but in dealing with the Young Offenders Act, are you teaching police officers in training of alternatives which are available through the Young Offenders Act?
Yeah, warnings,
cautions,
juvenile justice
conferences.
Yeah. So we address those and the parameters in which they can be or they are to be diverted. Young people are to be diverted to those options. We then have a lesson where the students are given a series of scenarios and they have to determine what's the appropriate course of action, a warning, a caution, or juvenile justice, or an arrest, possibly. We then have a lesson on dolly incapacts. And then we have another lesson in which they apply, again, the Young Offenders Act with some integrated concepts. So there's some ethical issues they have to consider, some communications issues they have to consider. And then the final lesson in that module is about the youth support networks like Rise Up program, the Rise Up program.
In terms of support for young people, is there ever any mention about young people at police stations? I know we're jumping forward a bit, but
There is.
what's taught about how young people should be managed if in custody?
They're taught if they're in custody. Well, we don't necessarily there is some lessons where we talk about vulnerable people. In the lesson on vulnerable people, we articulate that generally vulnerable people are vulnerable for a reason and you need to be, there's certain policies and procedures in place to ensure that they are dealt with appropriately. One of those is a support person, things like that, legal advice. So they're told about that. That's in regards to young people. They're also taught that they're not to be interviewed without a support person present. And they're also told that, on a bigger scale in relation to interviewing. Sorry, what was?
Sorry, yes, there is some static.
That's young people, but what you were talking about
Young people at police stations, but I'll come back to that.
Sorry, but the custody manager, the other thing we tell in relation to any person who comes into custody, into a police station, that you will take them to the custody manager, they must be taken to the custody manager, given to the custody manager. You're responsible and have a duty of care to that person until you're given to the custody manager, and then you will not do anything with that person until you've spoken to the custody manager and informed them. That's the other thing.
I'll return to that in more detail a little bit later on, but what I'm going to have put up on the screen now is Section 8 of the Children Criminal Proceedings Act. Perhaps we can just focus on Section 8, subsection 1 and the top part of subsection 2. Can you see there, Senior Sergeant Pocock, what Section 8 sets out is that criminal proceedings should not be commenced against a child otherwise than by way of court attendance notice, and then subsection 2 goes on to state the situations where it would be appropriate to commence proceedings by way of an alternative to a court attendance notice. Can you see that?
Yes.
What training is provided to police as part of the associate degree course on the substance of Section 8, commencing proceedings against children by way of court attendance notices as opposed to other alternatives, namely arrest?
we don't deal with Section 8 explicitly, or implicitly, sorry, but in and of itself, because we find for our students probably a little bit confusing for their interpretation of what a court attendance notice is. We teach field court attendance notices, and we teach for, there's a court attendance notice which is issued by arresting someone and taking them off to the police station, which for an untrained person they would see subsection 1 of 8 and understand that by way of, if I arrest someone, take them back to the police station and they're issued a court attendance notice, then
So
apply. So we don't teach that.
what do you teach about?
What we teach is we generally, for all people, we always go for the least restrictive form of sanction. Arrest is a last resort, and you will not arrest someone if there's another way of dealing with the matter. And for young people, specifically, I have to look at the 9 lessons in relation to what we teach about arresting them. I'd say we would rely on the general principle that it's a last resort always, least restrictive form of sanction. With a young offender, you've even got further opportunities to divert them away from by the young offender, via the Young Offenders Act. We teach PASS as well, which is Protected Admission Scheme. So,
The Protected Admission Scheme, which is a scheme which allows
which I
for
failed to.
certain admissions for the purpose of being eligible for
Allowing
youth
them to,
justice.
and we explain how, they might, so for example, they might say, I'm not saying anything. And we would say, well, we would teach that under the Protected Admission Schemes, if you explain to them the circumstances, we avoid us having to maybe arrest the person. There is some specific examples and scenarios that we do in relation to arrest.
Senior Sergeant Weston, I haven't forgotten about you. You've got some particular expertise in terms of use of force, which we'll come to later. Senior Sergeant Clark, was there anything that you can add in terms of specific training modules about alternatives to arrest for children?
I had a quick look at the Specialist Youth Officers course and I couldn't find anything in relation specifically to Section 8, but the principles that Senior Sergeant Pocock has expressed in terms of doing things in this manner, and as that feeds into Section 99 in particular, it would have some implication there whether we even get to the Section 8 issue.
Is there some emphasis about children and specific legislative provisions for children, meaning that the first course should always be an alternative to an arrest, that namely a court attendance notice?
If there's, in the context of Section 99, if there's no reason for arrest, if you can't justify the arrest under 99(1)(b), whether they be an adult, a child, or otherwise, it would be not necessarily justified.
I was just wondering whether there was some particular information about children and the specific legislative provision that I've just taken you to.
I haven't found any reference to Section 8 in our materials. I may be wrong, and I haven't spent that. I did a search through the material, but I couldn't find anything in the time I had.
Okay, turn now to...
Just before we move away from Section 8, and I hope I'm not cutting across what you plan to come to, Mr Fernandez, but just whilst it's in mind. Section 8 of the Children Criminal Proceedings Act, as we've been discussing, the criminal proceedings should not be commenced against a child other than by way of a court attendance notice. At earlier times, there was the distinction between charging someone's and summonsing someone, and therefore, usually, if there was an arrest, there would be a charge sheet, or a summons where there would be the word of the charge contained in it, and the distinction is a little clearer. Section 8 just talks about a court attendance notice, but as I understand it, every criminal proceeding has to be commenced by a court attendance notice. when one looks at the Criminal Procedure Act, section 47, for example, commencement of committal proceedings by court attendance notice, and then section 172, summary offences, commencement of proceedings by court attendance notice. So there needs to be a court attendance notice, or can, in every case. Now, is that the position as each of you understand it?
I'm not aware where summonses are still available, but that's my understanding as well. I
think they
read
might have
section
passed
8 in
into
that
history.
context.
Is there's such a thing as a future court attendance notice? Is that the modern day equivalent of the old summons, effectively?
I think they all count as court attendance notices. It's just
Yes.
the way that they are delivered usually, and you know, the options are a can delivered potentially in the custody room or the station, a bail can, a field can. But I don't think the law distinguishes between these, or a field can or a future can. But they're all just cans, I believe, Your Honour.
But there is a decision. There is a distinction in practice. For example, a decision may be made to charge or to prosecute someone. So a charge is formulated.
Yes.
Court attendance notice is created with a future court date, and that may merely be served on the person. A future can, or
Future service can, yes.
future service can. A longer word than summons, but perhaps the same meaning. And that usually doesn't arise after an arrest. It usually arises after there's been a consideration of a prosecution, a decision to prosecute, and there's the future service can. That's one species. If someone's arrested, goes to the police station, and there's a decision to prosecute, then there'll be a can, which may involve a bail determination as well. That's a different form of can. When you look at section 8, it just talks about can. And criminal proceedings should not be commenced against a child other than by way of a court attendance notice doesn't make a lot of sense, because every proceeding has to be commenced.
Yeah.
But when you look at subsection 2, it seems to be talking about things that relate to the seriousness of the charge, or whether the person's not likely to comply with a court attendance notice that he's turning up at court, or may be likely to commit further offences, or you look at the violent nature of the child or violent nature of the offence, things indicating whether the child should not be allowed to remain at liberty. They seem to be relating to whether there should be effectively a future court attendance notice used, or something else because of those factors. Is that the way this section is understood by those of you who have to teach this in practice?
Mr. Chief Commissioner, that's why we avoid it. That's why we don't include section 8. We, at our level, we think it's easier for our students to understand that they're to always apply the least restrictive, and so that's why we avoid that.
I can understand the caution there, because section 8.1 is a little ambiguous, as we've discussed, but it is still in an Act of Parliament and has an effect which applies particularly to young persons. And so it arises and has to be considered and applied, even though it's not without its complications. But what you're saying is that the training to take the least restrictive option effectively would encompass the considerations in section 8, certainly with respect to young persons.
Yes, we think we cover that with our curriculum.
Yeah.
And my understanding is you can't issue a field can to a juvenile either. So another restriction that
Where does that come from?
I have to find the particular legislation.
Don't worry about it right
right
now,
now.
but anyway, thank you. Back to you, Mr. Fernandez. I hope I didn't cut across your plan.
Commissioner, can I just say,
Yes.
Children's Criminal Proceedings Act, that as it was originally in 1987, the heading was, for this section, was commencement of proceedings by summons or citation. So if you replace what's currently there as summons or citation. So it seems they've amended the legislative provision to be a court attendance notice, but maybe not have had this regard to the fact that there's a number of different versions of the court attendance notice.
And that can happen where a separate piece of legislation such as this is not perhaps looked at with the same degree of scrutiny as the
Yes.
primary acts, and which doesn't assist police and those training police, and may not assist courts greatly either in the end. And it would be appropriate, I think, there be some clarification in this section, whatever else is done.
Yes.
Because lawyers and courts will look at this section quite apart from police. All right, thank you, Mr. Coffey. Yes, Mr. Fernandez.
Senior Sergeant Clark, part of your responsibility is specialist training. So does that include police specialist youth officers?
It's not my responsibility. The responsibility of the command includes specialist training in this, in particular the Crime Prevention Training Unit, which includes the Specialist Youth Officers course, yes.
I'm going to turn now then to section 105, which is about discontinuation of arrest. This is section 105 of the Law Enforcement Powers and Responsibilities Act. I'll just have, the section is now up on the screen. Senior Sergeant Pocock, the legislation there is before you. I'm going to ask you, what is taught as part of the associate degree in terms of what situations are appropriate for discontinuance beyond what's contained there in subsection 2, and what factors would guide a decision as to discontinue arrest?
We teach that if at any time you arrest a person, and to arrest a person you need a 99-1A, a 99-1B and a 99-3, that if the situation or conditions or circumstances change that might alter particularly the 99, well, any of those really, probably more likely to affect your 99-1B reasons, but arguably you could get some information that alters your position on 99-1A, then you are to discontinue that arrest.
Is there, do you use case studies?
Yes,
is there
we do.
discussion?
We do some scenarios in relation to that. There's also, it's a little bit of a how long's a piece of string, because at what point, if you've arrested a person, searched them, placed them back into the back of a police vehicle, taken them into custody, given them to the custody manager, and then the circumstance changes, but you're still going to issue them with a court attendance notice. So for example, let's say they haven't given you their name, and to ensure there's appearance at court, then you need to arrest that person because you don't know who they are and take them back to the police station. There's some variable there, and we have a discussion, I suppose, around if the person, of course, say the offender, decides to give you their name and address and details, and you're convinced that that information's accurate, then you're probably more likely to discontinue the arrest early on in their interaction. But the further you go down that line, arguably, if they're already in custody, you're halfway through the, you can't charge them, but, let's say something changes. All I'm indicating is that we do have a discussion around at what point in time that they would discontinue that arrest. So that's a discussion point we have with them as well, because it's difficult.
Just as there's a discretion to arrest, there's also the discretion to discontinue arrest if appropriate.
Yeah, and it says may. We highlight the fact that it does say may, it doesn't say you must.
And it also refers to it at any time,
Yes.
so that includes
Yes.
all of those different circumstances that you've just described. Senior Sergeant Clark, is there anything you wish to say about Section 105 in terms of your levels of responsibility and training?
I looked in the police handbook on arrests, and I think it specifically mentions section 105 there. I looked at an article called a law on arrests under LEPRA, or in front of me, arrests under LEPRA, which talks specifically about 105 and in particular about the alternatives that or the processes under the Youth Offenders Act as well, and how it may affect the continuation of the arrest, which very much reflects 105.2b in particular. So that is covered in those articles that are available through the portal.
I'll turn now to, we've just talked about alternatives to arrest and discontinuation. I'm now going to turn to another aspect, which is use of force. In terms of the use of force generally by police and the use of force in making an arrest. Just by way of introduction, can I indicate to each of you that there are documents in evidence in this investigation, and I'm going to take you to each of those documents. Before I take you to those documents, including documents from the Police Force Handbook on Use of Force and the Use of Force Principles, I'm going to start with you, Senior Sergeant Pocock. What is taught about use of force at a more theoretical level, and I'll turn then to you, Senior Sergeant Weston, in terms of the operational level. Can you assist us with that?
Yes, I can. We have a particular lesson on de-escalation and justifiable use of force, de-escalation and its relationship to justifiable use of force. We introduce the tactical option my colleague mentioned, but we don't teach it. We mention it, but particularly, we're not the subject matter experts on it. So we talk about de-escalation techniques. We talk about general rules for use of force, being that we use a minimal force operational environment. The use of force is considered as a last resort control option. Where a negotiated solution is not possible or has failed. Use of force is, we teach generally that the use of force is driven by an independent police officer, in the sense that we encourage that we will react to what we won't proactively go to using force. Always avoid it. We only step up when into that use of force if necessary, based on the action of the offender. We then introduce the ANSPA use of force principle, so we tie into what ANSPA, Australian New Zealand Policing Association.
We'll come to that very shortly.
With that, and we also teach that the purpose of the using of force is to gain compliance of a resistive, combative person of interest. And once compliance is gained, the justification for the use of force may not no longer exist. So that's an overview of it.
When you say you teach that the use of force is driven by the offender, you've referred to some of the actions of the offender.
Yeah.
What about the qualities of the offender? And what I mean by that is the attributes or the physical circumstances of an offender.
Yes.
And can I just indicate that this investigation is dealing with a 14-year-old Indigenous boy who's very small and was sizably smaller than two apprehending police. What is taught about that in terms of what is to be taken into account in terms of that reasonable use of force?
In essence, we look at the intention of the offender and the capability of the offender. So we teach, based on your assessment of the situation, what can you see in relation to the intention of the offender? What have you been told? What have you observed? What is the offender saying? And then we look at the capability. So we will use examples of 20-kilogram football player who's, says he's going to do certain things. He might have that capability of doing that, compared with someone who's a lot always the case, but we teach our students to consider the capability of the person, look at the situation, look at the circumstances, and make an assessment as best they can in that situation to determine what capability this person might have.
Is there anything more specific? Is there a discussion of case studies, matters to be taken into account?
I'm not certain.
You've referred to case studies in terms of other aspects of training. Does that exist here in considering or in teaching police about use of force in itself?
We have our own case studies as opposed, we have our own scenarios in respect to case studies, which are factual case studies. I'm not certain, I'd have to go and have a look. But we certainly have scenarios which provide a contextual situation where the students observe something, watch video, and then they discuss that video in relation to what they might have done. We had one video where we played it out and we deliberately played some excessive force, and we wanted the students to identify that force was excessive. And so that's part of our.
There are many situations that occur in the field, and you're doing your best to train police as to what those situations are.
Yeah.
I'm just going to ask about a particular situation because you stress the importance of working out the intention
Yes.
of the offender or the intention of the person.
Yep.
In the particular investigation that is being looked at here, a young person was chased by police, and it may very well have been because the police were undercover. The young person didn't realise it was a police officer who was chasing after him. In that kind of circumstance, what do you train police? How can a police officer know what to do and what level of force to use in that kind of situation in effecting an arrest?
Well, it would be difficult, and you'd have to consider things like even time of day, geographical and environment, what other resources were available, whether you knew the person. That would be a very important factor if you knew the person, because that might change the circumstances. And obviously we talk about age, size of the offender and what the original offence was that they're chasing the person for. But we don't go into the practical application component of how to limit hurting someone, I suppose, other than to say the academic understanding that we're there to achieve control of that person, and then that we've achieved our.
The use of force involves the use of weapons. I've asked Senior Sergeant Weston specifically some questions about that, and any consideration of use of force not involving weapons might also involve the consideration of use of weapons. But can I just ask you this, Senior Sergeant Pocock? Assuming a weapon was not to be used, is there any training or discussion about how or what types of force might be appropriate in a circumstance? Tackling, for example, or use of shoulders or anything else? Is there any discussion of that level of detail?
No, we sort of try and stay out of that area because we might impact the students' learning in regards to what they learn in the practical component with my colleague here, Senior Sergeant Weston, who they have particular techniques that they train, and it's never a perfect environment, so often those techniques, are impacted by certain things, which I'm sure we'll be able to speak to. But we try and avoid crossing the line in relation to that.
Let me turn directly then to you, Senior Sergeant Weston. I will bring the STOPAR up very shortly, but before I do, just in terms of general principles, appreciating that you're involved in practical training of police, what is it that you're teaching police about use of force, whether by use of weapons or use of hands or something else?
Yes. Well, our component of the ADPP works in cohesion with the academic side. So when we're breaking down into a physical component, it's also critical that our students understand concepts that are just as critical as a physical aspect. So for example, and I know we'll speak to Stopar shortly, we talk about risk and threat assessments, which are our decision-making models to determine the use of force or the need for force. We talk about what is a reasonable level of force. We talk about excessive force. That might be me, sorry. Excessive force and the four definitions of what would equate to excessive force. A person using force when no force is required, using more force than is necessary, continuing to use a level of force once the need no longer exists.
Just hold on, the officer who's the expert in the room, I think.
The tech guy.
All right, see how we go.
Okay, thank you. So we're talking about our excessive force, knowingly willful use of, wrong use of force, and a well-intended accidental use of force resulting in an undesired use of force. So before we get into our physical aspects, we also have to
I'm sorry, just trying
No,
to
you're
make an
right.
inquiry about that microphone.
yeah, it's no good.
I wonder, Chief Commissioner, because it seems like the microphone is getting in the way of giving of evidence. Look, we might just break now. It's 10 to 1.
Take an early break for lunch.
We'll just see if we can work this
We'll
one.
see if it's been mainly good with some occasional fluctuations. So I think just give us a break now and see if we can overcome the imperfections. Is 10 to 2 an appropriate time to resume? If you wouldn't all mind stepping down or stepping up for the purpose of the break, and the evidence and the hearing will continue in an hour. So the Commission will adjourn until 10 to 2.
Silence, all stand.